The backstory of Brown versus Board of Education goes back to the Supreme Court case of Plessy versus Ferguson in 1896. In Plessy versus Ferguson, it was ruled that racially segregated public facilities were legal, so long as the facilities for blacks and whites were equal. This led to laws barring African Americans from sharing the same buses, schools, and other public facilities as whites. And the Jim Crow laws, as we know today, established the separate but equal doctrine that would stand for the next 6 decades. So after that, we fast forward to 1951. A plaintiff named Oliver Brown filed a class action suit against the Board of Education of Topeka, Kansas, after his daughter, Linda Brown, was denied entrance to all Topeka's all-white elementary schools. In his lawsuit, Brown claimed that schools for black children were not equal to the white schools, and that segregation violated the so-called Equal Protection Clause of the 14th Amendment, which holds that no state can deny to any person within its jurisdiction the equal protection of the laws.
Attorney of Topeka argued that the separate schools for non-white Topeka were equal in every way and were in complete conformity with Leslie's standard. Building the courses of study offered and the quality of teachers were completely comparable. In fact, because some federal funds for Native Americans only applied at the non-white schools, some programs for the minority of children were actually better than those offered at the school for whites. They pointed to the Plessy decision in 1896 to support segregation and argued that they had, in good faith, created equal facilities, even though races were segregated. Furthermore, they argued discrimination by race did not harm children. Linda Brown's argument led by Thurgood Marshall, an AACP litigator who would be appointed to the court in 1967. Brown's attorney argued that the operation of separate schools based on race was harmful to African American children. Extensive testimony was provided to support the contention that legal segregation resulted in both fundamentally unequal education and low self-esteem among minority students. The Browns' family lawyer argued that the segregation by law implied that African Americans were inherently inferior to whites. For those reasons, they asked the court to strike down segregation under the law.
So, on May 17, 1954, Supreme Court Justice Earl Warren ruled that state-sanctioned segregation of public schools was a violation of the 14th Amendment. On February 24, 1955, Senator Flood Byrd stated, "If we organize the southern states for massive resistance to this order, I think that in time the rest of the country will realize that racial integration is not going to be accepted in the South." So in 1955, the Gray Commission proposed ways to avoid fulfilling the mandated segregation. The reasons why were because laws would change, meaning no child would have to attend a segregated school, giving tuition grants to parents who opposed desegregation in schools, and deciding what school black and white students would attend.
Our opinion on the Brown versus Board trial is that schools needed to be desegregated, and that separate but equal is never really equal, and that there was no reason to have an African American and a white minority go to different schools just based upon their race.
The presiding justice of the Brown versus Board of Education case was Earl Warren. Earl Warren became Chief Justice following a nomination from President Dwight Eisenhower. Chief Justice Warren was able to find a consensus with the Associate Justice in the 1954 decision.